Hello, my name is Mick Murray and I'm a careers advisor working for C&K Careers with Kirklees Youth Offending Team, also known as the Yacht. This session's intended for you if you've been in trouble with the police and are worried about how this will affect you in the future. In the session, we look at the circumstances in which you need to tell people about your offences, the circumstances in which you don't, and how best to tell them if you do need to. I should say that everything I'm going to talk about in this session applies to you if you committed your offence before the age of 18. Things are slightly different if an offence was committed after that age. And I should also say that you can get help with this from me, or from your yacht officer, or from an organisation called NACRO, the National Association for the Care and Resettlement of Offenders. And there will be contact details for all of these at the end of this session. The first thing to say is don't panic. You may have made a mistake, but that doesn't necessarily mean that you can't do what you'd planned. The law actually helps with this in the form of an Act of Parliament called the Rehabilitation of Offenders Act. This says that under most circumstances for many offences, an employer or course provider isn't allowed to ask you about your offences or count them against you once a certain length of time has passed. Let's look at that in a bit more detail. How it works is that under the Rehabilitation of Offenders Act, most offences become spent. What this means is that once it's spent, an offence no longer needs to be disclosed to employers or course providers, although there are some important exceptions which we'll go into in this session. How long it takes for an offence to become spent depends on the penalty that you got for the offence. That penalty is also known as a disposal. So let's look at some of the main disposals and how long it takes them to become spent under the Rehabilitation of Offenders Act. Some minor offences are dealt with by a short disposal called a community resolution. A community resolution is not part of a criminal record and doesn't normally need to be disclosed. Slightly less minor offences are dealt with by cautions. A simple youth caution becomes spent immediately it's imposed, so it rarely needs to be disclosed. A slightly longer caution, a youth conditional caution, or YCC, becomes spent either 3 months after it's imposed or when it ends, whichever is sooner. Typically, a YCC will be for a fairly short time, and say a month, and after that month, you will no longer need to disclose it. If it goes on for some reason, if it goes on a long time, even if it goes on for 3 or 4 months, you will not have to disclose it after 3 months from when it was imposed. Quite a lot of offences are dealt with by a referral order. This becomes spent at the end of the order. Typically, a referral order will end with a final meeting of the referral order panel. Once the order is signed off at that panel, you no longer need to disclose it. The rules for youth rehabilitation orders are a bit more complicated. A YRO, as they're called, still needs to be disclosed after it ends for a period of time known as a rehabilitation period. This lasts for the length of the order again, plus 6 months. So, if your YRO was 12 months, at the end of the order, it still needs to be disclosed for another 18 months. The 12-month length of the order plus 6 months. I should also give a health warning here that some offences for which YROs are imposed, such as sexual offences or offences of violence, may be exceptions to this. So if you have any doubts, contact the NACRO helpline. And also for any more detail about any of this, and also for other disposals which I haven't put on this chart, for instance, detention and training orders, which are custodial sentences. DTOs are a bit more complicated. I haven't put them on this chart, but you can get information from two sources. You can get information from the NACRO website, and the link for that is below the chart here, which you're looking at now. If you can't use that link, just Google NACRO and follow the links and you will get there. NACRO also runs a helpline, and details of that helpline are at the end of this session. So those are the rules about what needs to be disclosed under the Rehabilitation of Offenders Act. However, there are some exceptions to this, and you need to know what they are. Some occupations are exempt from the Rehabilitation of Offenders Act. Typically, they are occupations which include contact with children or vulnerable adults. So they would include care work, nursing, teaching, medicine, social work, careers work, yacht work, and similar jobs. And this also applies to courses that lead to such jobs, particularly because most such courses will include work placements that involve contact with children and vulnerable adults. And there are also some occupations which don't require courses, but which will still be exempt from the Act. These will be occupations like school caretaker, school support assistant, transport assistant. Those kind of jobs will also be exempt from the Rehabilitation of Offenders Act. What these jobs have in common is that they require a disclosure and barring service check. Disclosure and barring service is known as the DBS. Disclosure and barring service used to be called the Criminal Records Bureau, and the check used to be called a CRB check, and you may have heard of that. DBS checks come in 4 different kinds at 4 different levels: basic, standard, enhanced, and enhanced with barring. But what we're mostly concerned with here is enhanced checks. All of the jobs that the occupations that we've talked about here will require an enhanced disclosure and barring service check. If you are going to have a basic DBS check, that will basically just show up unspent convictions. So you wouldn't need to disclose anything else. But what we're really talking about here is an enhanced DBS check. You will know that you're going to have a DBS check, and you should know what kind it will be, because you and the employer will fill in a form requesting the DBS to do the check. So if you're asked to complete the form, you'll also be asked for some identity information. If you're asked to do that, it's a good idea, before the check comes back, if you think that something will be on the check, you just should disclose that thing before it comes back. Not all offences will appear on a DBS check. It depends on the disposal that you got for the offence. A community resolution will almost certainly not show up. Youth caution, youth conditional caution will probably show up on a standard or enhanced DBS check, though not on a basic check. Any disposal higher than a caution is very likely to show up on a standard or enhanced DBS check. So a referral order, a youth rehabilitation order, and not on this chart, but a detention and training order is very likely to appear. I should say that there is some uncertainty about all this. It's changed in the past and may well change again because of changes in government policy and decisions in the higher courts. So when it comes to your particular case, it's worth checking either with your yacht officer or with me or with an ACRO helpline whether we think that it will show up in your particular case. So if you do need to disclose an offence, how do you go about it? Here's my advice. First, put it in writing. Even if you intend to disclose it verbally in an interview, it's a good idea also to have it written down for at least two reasons. One is that the process of either you writing it down or getting somebody else to write it down for you will help to fix the story in your head so that when you come to tell it, you'll tell it better. The other reason is that even if you do disclose verbally, the organisation that you disclose it to might need it in writing as well for their records. Second piece of advice is don't put convictions in a CV. A CV is a positive document and should contain positive things about you. Don't put negative things in a CV. Never tell untruths in a CV, but make it mostly positive. I'd suggest that the place for convictions is in a separate document, probably a covering letter or email. The next issue is who to disclose to. Not everybody in an organisation needs to know about your offences. You need to identify the person in the organisation who's most appropriate and disclose to them, either verbally or in writing, and leave it to them to let other people who need to know in the organisation. Take the example of Kirklees College. If the offence that you need to disclose is an unspent conviction, you will already have told the college early on in the application process. What you'll have done is tick a box on the original application form that says you have an unspent conviction. This will lead to you being sent a more detailed form and probably interviewed either by phone or face-to-face by a member of the safeguarding team. So by the time you get to college, the people who need to know will know in the college. It's important to realise that not everybody in the college will know. The people who almost certainly will know will be your progress coach, somebody in the safeguarding team, and probably somebody fairly senior in the department that you're in, but it might well not include the teachers if they don't need to know. If the offence that you need to disclose isn't an unspent conviction and you didn't tick the box in the application form originally, you might need to identify somebody to tell. I would suggest that the first place to go is a progress coach and the second place is a member of the safeguarding team, and then the process will kick in again. What should you put in your disclosure? Well, you should certainly say what the offence was and what the penalty was, and if you don't know the kind of technical details of this, you can come back to the yacht or contact me, and it should be on a system somewhere and I'll be able to tell you exactly what it was. You should then describe the circumstances of the offence. In particular, if there are any circumstances that make it better for you, mention them. For instance, if you feel that you are led into it by other people, don't name the other people, but mention this fact. It's even better if you've changed your friendship group because it indicates that things are different and it's less likely that you repeat the offence. I would suggest that you be cautious about claiming that you're innocent of the offence. you have been either convicted or admitted to it if you've had a conviction or are on an order. So it's better to admit it, but say that things have changed now. You should emphasize how things have changed since the offence was committed, and say what you've learned, and say how determined you are never to commit the offence again. You should emphasize also that the offence doesn't mean that you're not suitable for the job or course. The point is that what you're trying to establish is that you're still capable and suitable to do the job that you want to do, and you have to convince the employer or the course provider of that. If you can do that, whatever your conviction or offence, you may still have a very good chance of getting where you want to get. If you need more help or information about the issue of offences and disclosing them, there are a number of people that you can get help from. I'm one, and my contact details are there in front of you now. If you'd prefer to talk to a yacht worker, either one that you've got at the moment or one that you had in the past, you can contact Kirklees Yachts, Huddersfield and Batley officers on the numbers that are under my name in the slide that you're looking at the moment. The other main place that you can get help is NACRO, which is an organisation called the National Association for Care and Resettlement of Offenders. They run various forms of help and advice, and their contact details are there. You can telephone them, there's an email address, and there's also a website. If you need more general careers advice and you're still working with the youth offending team, I'm very happy for you to contact me. Again, my contact details are on the screen in front of you now. If you'd prefer to talk to another careers advisor, or if you're no longer working with the yacht, it would be a good idea for you to contact C&K Careers, and you can do that through the chat service. You can do that either by phone, by email. There's a Facebook page, and C&K Careers has a website. Details of all of those are on the screen that you're now looking at. So that's the end of this presentation. I hope it's been helpful, and it just remains for me to wish you the best of luck. Do come back to me if there's anything else you need to know.